Listening to you, there seem to be loads and loads of monies flying all over the place, talking about these monies, which he actually said it's on China's television on our program Business Morning, where he said that money was borrowed. But we're looking at another sore issue that people would like to get clarification on, and it has to do with the proposed, should I say, bailout of these shareholders.
I believe you are referring to the capital market.
Yeah, the capital market operators, yes.
Well, thank you very much. It all still boils down to the fundamental issue of transparency and accountability on the part of government. Now, the bailout funds being proposed as an intervention for capital market operators is also questionable if you are going to look at it, stricto sensu. Why? Because margin loans were alleged to have been traded in the capital market some time ago, and this resulted in the collapse of the market. And I keep asking, what is the definition of margin loans? In simple terms, they are contracts. Now, these were contracts entered into between stockbroking firms and certain banks. I refer to my initial proposition that the veil of cooperation must be lifted if this country must know the true facts and situations that are on ground. If banks entered into transaction with stockbroking firms, and in practice you realize that most of these stockbroking firms are partially owned by the banks. So they engage them, take our loans, use it to buy our shares, and trade these shares on the market. Once that happens, there's a high volume of money flowing in the market, and investors are deceived into thinking that the shares of the company is doing well. They put their money into it, buy the shares, and all of a sudden we just heard that the bubble burst.
Yeah, but don't shareholders hold these regular briefings, meetings where they inform them of what's going on, what the company, how the company is performing?
Well, you are reminding me of the case of Force and Abotu, which limits the right of shareholders to participate in core decision-making aspects, of a corporate structure. That's Section 299 of the Companies and Allied Matters Act. So the shareholders are limited when it comes to particular issues, that borders, on operating, the company. So that is an answer to your question, I believe.
Okay. Well, shareholders, in other words, are you implying that they do not have the means to call? I mean, if all the shareholders come together, they cannot call for an emergency meeting?
There are several procedures laid down under the Companies and Allied Matters Act where shareholders can call, for an emergency meeting, like an AGM, and all that. You can check that, under our laws. But the truth of the matter is, when it comes to decision making that has to do with, fundamental issues, then you are looking at the superior board, the board of directors that deals with the proceedings of the companies, make these decisions, by resolutions. So that is why I said that the veil must be lifted so that we can know who the alter ego, who are those responsible for the management, of this company in terms of core decisions being taken.
Well, speaking of which, there was also this matter where I think it was shareholders too. I'm not sure if it was a Shining Bank, but the matter concerned the Shining Bank. Remember where CBN had recovered some 191 billion naira assets forfeited by the former managing director of Shining Bank, and some chaps went to court, and the court ordered the CBN to come up because they wanted to find out the monies that were recovered. They have 191 billion naira in assets. What was it supposed to be? Are they supposed to? Is the CBN supposed to plow that money back into Oceanic Bank, or divest or do some other things with it? Because that's what people seem to be confused about. What does it state?
Well, the position of the law on that is very strict because you have the AMCON, then you have the Public Procurement Act. Now, that is why people are still bothered that AMCON's operations lack transparency.
Perhaps maybe you clarify on that. What do you mean by transparency and accountability when you say it's shrouded in...
There's a principle in law that has been established several years ago. I refer to the case of Attorney General of Ondo State and Attorney General of the Federation. That case is reported in 2002 9 Nigeria Weekly Law Report, part 722 at page 222. There, the Supreme Court was very emphatic in describing the duties imposed on organs of government. Now, there's a duty on the state, pursuant to Section 15, to ensure that corruption is abolished. But that duty is in Section 15, which is just a directive. It's a mere directive. So the Supreme Court said that a mere directive is just a directive. The only way you can enforce a directive is by making it a legislation. That was when the ICPC Act was passed. Then the ICPC became a body empowered to enforce the duty to abolish corruption. The same thing goes for accountability and transparency that I've been speaking about. Now, Section 16 of the Constitution talks about the duty of the state to ensure that the economy is stable and to ensure that there's transparency in the economy. Now, that duty will have been a mere directive because of the case of Mangro and Buji Budi municipality that the Supreme Court referred to, SUPRA. Now, by means of the Fiscal Responsibility Act that was enacted, that duty has now been enforced by legislation. Now, it is now incumbent on the Fiscal Responsibility Commission to enforce that duty of accountability and transparency. But I ask you a question today. The Fiscal Responsibility Commission, do they exist in Nigeria? Does anybody know where their office is? These are the kind of questions that we should be asking, because they have the duty to check what is going on within the CBN today.
Does it mean that is not happening?
It is not. It means that it is not happening. Res ipsa loquitur. The fact speaks for themselves. Because that is the essence of the Fiscal Responsibility Act. In fact, the preamble says that this is an act to ensure transparency and accountability in governance. It now imposes the duty to enforce that transparency and accountability in governance on the Fiscal Responsibility Commission.
You know, this is will the CBN Amendment Act help in this situation?
You have asked a very sound question, and at this moment, I would like to pass a message to the National Assembly. The CBN Amendment Bill that is before the National Assembly, I want to believe is the most important bill in the history of Nigeria.
Why?
Why? Because presently, there is an individual that is in custody of the power to determine the fate of Nigerians in terms of the currency that Nigeria is using today. Who controls the inflationary rates? Who controls interest rates in this country today? The answer is in Section 17 of the CBN Act. It says that the CBN shall have the sole right to issue currency, to make coins, and to make them pass as legal tender. And if you look at Section 22 and 20 of the Act, the CBN Act, it says that the CBN has the right to issue these currencies, and it must be accepted as legal tender in satisfaction of payment of any obligation and debt. Now, this power to make money legal tender is vested in the CBN today. That is why the man at the helms of the CBN, Malam Sanusi Lamido, has been questioning the National Assembly's approach in amending the CBN bill, because it portends great danger to our society. Why? Because by virtue of the exclusive legislative list, I'm talking about item 7 and item 15, the power to make currency and to make money legal tender is rooted in the legislature, in the National Assembly. But by virtue of the CBN Act, that power has gone to the CBN based on the sections I just cited in the CBN Act. So I want to believe that the National Assembly now must understand their duty in the CBN Amendment Bill, because their essential duty is that there is a contest for power. The National Assembly may want to take back that power.
I mean, there's always been this conflict.
Yes, there's always been this conflict, and that is what most opinion molders and experts have shied away from. It is a dangerous conflict, and this conflict may eventually be resolved at the Supreme Court.
Why Supreme Court?
The question is this a constitution which empowers the legislature not supposed to be superior to the CBN Act?
Thank you very much. By Section 1 of the Constitution, the supremacy of the Constitution has been enshrined at the Go-Aneji Oyo State. And it says the Constitution is supreme and binding on all authorities and persons. And any law, I'm referring to subsection 3 now, that is inconsistent with the provisions of the Constitution, that other law is null and void up to the extent of its inconsistency.